Hello, and welcome to PubK's 2023 Government Contracts Annual Review. We're thrilled to have almost 4,000 registrants for this program. Over the next 4 afternoons, we will present 12 different sessions with over 38 presenters and almost 20 hours of content. We hope you'll be able to join us for most, if not all, of these sessions, but a separate registration is required for each session if you want to attend. My name is Alan Schwatkin. I'm the president of the PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator for this year's annual review. The PubK Group publishes 4 newsletters: PubK Law, PubK Compliance, PubK Cyber, and our newest, launched in mid-2022, PubK M&A. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you joining this annual review were not yet subscribers. I hope you'll consider becoming a subscriber. Information is at the website shown on the slide or is available from any of the contacts you have at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I encourage you to look at the skills and capabilities that these firms have and use them as you see fit. Also new in 2022, PubK joined with Arnold Porter to launch a periodic podcast called Bonafide Needs, covering emerging issues and interesting interviews. We'll continue that in 2023 as well, and I encourage you to access them through our website. If you're interested in partnering with PubK on a webcast, we'd be pleased to discuss this opportunity with you at your convenience. In lieu of speaker gifts and in honor of our sponsors, PubK is making a contribution to the Capital Area Food Bank. With the food crisis facing our communities, including in the military and here in the Washington, D.C. metropolitan area, I hope you'll consider making an individual or an organizational contribution. Since the entire program is being held virtually, all attendees will be in listen-only mode. Your video will remain disabled throughout this session. But we do welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it will not be possible to answer all of the questions in real time. We're capturing your questions and will endeavor to answer as many as possible after the conclusion of the annual review. All presentation slides, along with the audio, are available for download now from the PubK Group and probably within a week or so at the conclusion of the full annual review. We'll send an email when this information is available for download, how to access it, and for how long the material will be available. We're also applying for continuing legal education approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect that acceptance within the next few weeks. Again, we'll notify all attendees when those approvals have been received. Finally, if you're interested in obtaining CLE, please look for our 2 poll questions during this presentation. Some states board require us to verify your participation during the event. We will keep track of the responses to verify that you viewed the panel. If you don't wish to obtain CLE, you can just disregard the poll question. Now I'm thrilled to kick off this 8th PubK annual review with our session 1 panel on bid protest. Our distinguished panel members are Rich Rector of DLA Piper, Jay Carey of Covington and Burling, new this year, Adam Lasky of Seaforth Shaw, and last but certainly not least, Craig Holman of Arnold and Porter. Rich, let me turn it over to you.
Rich, you're on mute.
When and how properly raising reason.
This is an important issue for three reasons. First, as we know from GAO's bid protest statistics, agencies were corrected.
And so, given the frequency of both corrective action and the situations in which additional information is offered during the context of a protest, it's important to understand the rules surrounding them. This is also an important issue because the rules are materially different at the GAO and the Court of Federal Claims. A new explanation for an award decision is permitted under some circumstances at the GAO, but is more likely to be rejected as post hoc rationalization at the court. So in assessing strategy and likelihood of success, it's important for practitioners to know what can and can't be fixed, as well as when those fixes can occur. Finally, I think the issue is increasingly important because in cases at the Court of Federal Claims, the court has the option of remanding a procurement to the agency in certain situations. In other words, as the remedy for a procurement error, the court can send the procurement back to the agency with direction to provide additional explanation for an inadequately documented decision, or in some cases to make an entirely new decision. I don't have statistics on this, I wish I did. But my instinct is that such remands are on the incline, on the rise at the court, and could be used more frequently in the future. So whether you work for the government or the contractors in bid protest issues, you should be mindful of what can and can't be done by an agency on remand. So what are the rules in this situation? When and how can an agency offer new or additional information to support a protested procurement decision? Let's look at these questions through the lens of decisions that were issued in 2022. And let's see if we can describe the landscape currently and also look ahead a bit and predict what might come in the future. So here's the standard at the GAO. It's on the screen now. And it has three key principles built into it. This is taken from a case in 2022, Aprio, and it's a good summary of the standard. There's three principles here, I think. One, GAO does not limit its consideration to the contemporaneous record, but instead considers all information provided, including the parties' arguments and explanations. As most of you know, at the GAO, the agency is required to provide a contracting officer's statement of facts. So the GAO's rules contemplate that there may be information outside of the record created during the procurement. And the GAO routinely considers information included that is in the contracting officer's statement. The second principle is that the GAO generally will give little weight to reevaluations and judgments prepared in the heat of litigation. Fair enough. That means that if there is, in particular, a reevaluation of proposals to suggest perhaps that the matter is not, that the protester has not been prejudiced, then that information may be given less weight or excluded. Let's go back to the prior slide. And then the third principle is built into the last couple lines there, which is that post-protest explanations that provide a detailed rationale for contemporaneous conclusions and fill in previously unrecorded details will generally be considered. So if there's a gap in the record, or if the contemporaneous record says that the agency did X, but there's not enough explanation for why it did X, the GAO will generally allow the agency to provide that information during the protest, provided, and the last two provisions here, provided that the explanations are credible and, importantly, consistent with the contemporaneous record. I think that last point, consistent with the contemporaneous record, is maybe the most important. We'll touch on that in a couple decisions that we'll mention from this year. Okay, next slide. The rationale behind not accepting post-protest explanations that are new judgments or new evaluations was explained in Rice Solutions this year. It refers back to, or it quotes a Boeing-Sikorsky case. Basically, if the analysis is prepared in the context of litigation, it's going to have less weight because the party preparing it is more likely to have or be influenced by the ongoing litigation. And that Boeing-Sikorsky case from '97 was really important. In that case, the agency prepared a evaluation that factored in the protesters' allegations. And so it said, okay, protester has alleged these things. Even if that's true, here's the outcome of the evaluation. Redone, a hypothetical reevaluation, and the awardee still wins. And the GAO made this statement in the context of that case, and it afforded little weight to that post hoc reevaluation. So there's a difference between a post hoc reevaluation or judgment and a post-protest explanation, and therein lies many a page spilled in briefs at the GAO. Let's go to the next slide. In this year, in 2022, here are some cases where the GAO accepted post-protest explanations, and that term, post-protest explanation, by the way, is the term that GAO prefers to use. In TEA Enterprises in October, an explanation for how an awardee's past performance satisfied the solicitation's relevancy and recency requirements was permitted. In KPMG, in November, the GAO accepted an agency's post-protest explanation of a variance between total evaluated prices. In eCuber Ventures, the GAO accepted a post-protest explanation of why weaknesses had not been assessed for proposed personnel. That last case is interesting because this is a common area where post-protest explanations are accepted by GAO, and I would say, well, for a good reason. And that is that if a protester argues that a particular weakness should not have been assigned or a strength should have been assigned, that won't necessarily and usually won't be reflected in the record. The agency is not required to document its evaluation with regard to every requirement. And so the GAO has said, you don't have to prove a negative. You don't have to show in the administrative record why a weakness was not assigned or why a strength was not assigned, but you do have to address that through a post-protest explanation. And we'll see a case on that in the next slide. So here were cases at GAO in 2022 where post hoc statements were not accepted, or, well, let me explain. There's three different cases. The first case, the statement is not accepted. That's Aprio. And in that case, GAO sustains the protest and rejects a post hoc statement regarding cost realism analysis of the awardee's proposal. And so from the facts of the case, the agency did an analysis after the protest was filed of cost realism. And GAO says, look, there's just no evidence in the record, and you agency have not even said that this analysis was conducted during the procurement, and therefore we're going to sustain the procurement. It was not consistent with the post-protest statement, was not consistent with the contemporaneous record as required by the standard we talked about. Similar outcome in Rice Solutions, sustaining the protest, and they're affording less weight to a post hoc statement that the agency said they created a de facto competitive range. And their GAO noted that there was nothing in the record, contemporaneous record, about a de facto competitive range, and therefore it was going to give that argument less weight. It still nonetheless considered the argument, but gave it less weight. The last case, Tech Marine business, the GAO sustained a protest where the agency essentially provided no explanation for the failure to award a strength. So this goes back to the issue that we talked about on the previous slide. There's an absence in the record of why the agency failed to award a strength. That's not a problem from the GAO's perspective. You don't have to prove a negative, but you do, the GAO said, have to come forward and provide some evidence or explanation for why the strength was not assigned. In that case, the Navy essentially argued that it didn't have to do that, relying on case law about not having to prove a negative. And the GAO very carefully distinguished those cases and said, no, you do need to address allegations through a post-protest statement if an issue has not been addressed in the record. And so this case isn't so much an example of the GAO not accepting a post-protest explanation as it is an example of a failure by the agency to provide a post-protest explanation that could have otherwise saved them. Okay, let's talk now about the standard at the Court of Federal Claims for post hoc statements and remand. Next slide. The lead case here now is really a Supreme Court case called DHS v. Regents of the University of California. And let me just walk through quickly the facts of that case so you can understand where the agency or how the court came out. In 2012, under the Obama administration, the Department of Homeland Security, or DHS, announces an immigration program known as the Deferred Action for Childhood Arrivals, DACA. It was in the news. You've heard of it. In 2017, the Trump administration advises DHS to rescind DACA because it is unlawful. And the DHS secretary at that time, Secretary Duke, does so by issuing a memorandum revoking the program. The rescission was then challenged in the courts, both on constitutional Fifth Amendment grounds and as a violation of the APA, the Administrative Procedure Act. And in April 2018, the DC Circuit grants judgment for the plaintiffs and on the APA grounds, and finds that the secretary's conclusory statements were insufficient to explain the change in the agency's view of DACA's lawfulness. So faced with that decision from the DC Circuit, DHS issues a new memorandum 2 months later. And Secretary Nielsen at that time identifies 3 reasons why the agency believes that its rescission of the DACA policy was and remained reasonable and sound. It gets to the Supreme Court in 2020, and Chief Justice Roberts writes for the majority, and he focuses on the APA issue. And he finds that the agency acted unlawfully and remands the issue to DHS to consider the matter anew. And what the court found is reflected on the slide. The Judge Roberts said that an agency must defend its actions based on the reasons it gave when it acted, when it is operating under the Administrative Procedure Act. And it is a foundational principle of administrative law that judicial review of agency action is limited to the grounds that the agency invoked when it took the action. Nothing new about that. That's black letter law. But it's reinforced by the Supreme Court in the Regents case. And then the Supreme Court, it goes on to talk about remand. And this is an important aspect of the case. And what it says is, if an agency has identified grounds in its decision that are inadequate, a court can remand for the agency to do one of 2 things, 2 options. The first is the agency can offer a fuller explanation of the reasons it used at the time to make its decision, but it can't provide new reasons. And secondly, the other option is the agency can examine the issue afresh and make a new decision. So those are the two options, very important. And what the court did was, applying this framework, it finds that the original decision, I'm sorry, it finds that the second decision by Secretary Duke was not new agency action. Rather, the court finds that it was an explanation of the original decision with some additional reasoning added to it. And it therefore treated the second DHS memo as a post hoc rationalization that was not properly before the court. And it analyzed the case solely on the subject matter of the first memorandum. And ultimately, the court found that the agency's reasoning in the first memorandum was arbitrary and capricious because DHS had failed to consider two conspicuous aspects of the problem. So Regents is now the leading authority on post hoc rationalization and remand at the court, and it's being cited more frequently in Court of Federal Claims cases, as we'll discuss here shortly. But there's an important second case from the Supreme Court in June of 2022 that's very similar on facts that you should know about as well. That case was Biden v. Texas. And in that case, as in Regents, there are two memoranda issued by the Department of Homeland Security. In this case, they involved the rescission of the Migrant Protection Protocols program. And again, in the second memorandum, there are new reasons offered for the rescission. The background is that in this case, the district court had found that the original memorandum was deficient under the APA. It goes up on appeal. While it's up on appeal, DHS says, well, let's fix it. They issue a second memorandum. And in that second memorandum, they expand on the reasoning for the rescission of the program. So it's very much like Regents factually. Two different memoranda. The second one is more detailed than the first. But what was different is, probably learning its lesson from the Regents case, the Department of Homeland Security in this case said, we hereby expressly supersede and rescind the prior memo, and we're issuing a new memo that reflects final agency action on this issue. And they then go on to address the deficiencies that were noted by the district court. So it's much like a corrective action in a protest where you have a decision, an agency's taking corrective action, and it's addressing the issues, or at least some of the issues that have been identified as errors in the original procurement. The Supreme Court said that's materially different than Regents. What you did in this case, unlike in Regents, was you created a new final agency action. You took a new action. You pursued the second prong of what Justice Roberts said you could do under Regents, which was take a new action. And so the court upheld the agency's position in this case and did not find that the second memorandum was post hoc rationalization. So very, very similar cases, two different outcomes. What's the distinction? The distinction is the agency in the second case made very clear that it was taking new agency action. I think this is instructive for agencies and for protest counsel in the private bar, and would suggest that it's analogous to a protest in which corrective action is being taken. And I think there are a couple takeaways. One is, when an agency takes corrective action in response to a bid protest, it should make sure that it is considering the matter afresh and taking new agency action. And if it doesn't take new action, if instead it offers reasons to support its original decision without identifying a new agency action, that kind of corrective action would likely be considered post hoc rationalization under Regency. So I'd like to get my panel members to to perhaps give us some thoughts on this. I think it raises a question for the future about what it means when an agency takes partial corrective action. Happens all the time. Partial corrective action. Is that the kind of action that the Supreme Court would say complies with the procedural requirements for a new agency action? Or might there be some ambiguity there that could be the basis for a challenge? Craig, I think you've thought about this a little bit in the past. What do you think?
I think that's a great question, Rich, and I think you're right to cite to DHS. I think we've seen it increasingly cited at the Court of Federal Claims. It is an area of distinction with GAO, and I think in the context of partial corrective actions, I think there's an argument, for instance, if you go back and look at past performance and you redo past performance, and certainly you've arguably redone past performance afresh, but if that leaves other pieces of the procurement puzzle in place, the other aspects not.
Yeah, I think that could be a question that arises in certain circumstances. Adam or Jay, any thoughts on that?
I think you're going to talk about the IP case next, which I'll say in the front, I would represent one of the parties in. But that case was remanded and the government was given 3 options. And I don't want to go into your section on that, but I think that what the government chose to do was stand by its original decision and provide a clear explanation for it, rather than provide a new explanation to support its original action. In part, I would suspect because if they had taken the second choice, it would have opened the door to questions of, okay, now we've got a new agency decision. Do we now have to go look back at other elements of the procurement as they stand based on the information we have today and the circumstances of today, as opposed to what we knew at the time of award, which in that case was like a long time prior to that.
Sure. Yeah, I think in the language, the key language from the Regents case is, as I said before, if an agency decides to take new action, which it can. Now, all of this, a remand can also be limited, and the court can provide direction on what the agency is to do. So this assumes that you have a general remand without a specific direction. In that case, the agency can take one of two actions, according to the Regents. It can offer the fuller explanation or examine the issue afresh and take new action. The key language, I think, is on that second part. If you're taking new action, it has to comply with the procedural requirements for new agency action. So I think in our case, the question would be, well, what are the procedural requirements for new agency action in a new award or a new evaluation? And I think that would be the kind of narrow legal issue that you'd look at. All right, let's go to the next slide. Post hoc statements and remand at the Court of Federal Claims in 2022. I mentioned that Regents has been cited a couple times. And in the case that we just discussed, IAP Worldwide Services, Justice, I won't make him a justice yet. Judge Solomon said, the court will not put words in an agency's mouth or invent supporting rationales. The agency has not itself articulated in the administrative record. Post hoc explanations for agency decisions ordinarily will be rejected. And then that was in the merits decision, which is the public version of which is issued April 5, 2022. And then in the remedy decision, which is later in the year, the Judge Solomon, says the court cannot permit the Army to supplement the administrative record with analysis that it did not undertake at the time the Army moved forward to make an award without properly considering DFARS 215-306. That's the DFARS provision that requires the DoD not requires. It says the DoD should conduct discussions for procurements for $100 million or more. And that's a key part of that decision. The decision is important for many reasons, but I think these quotes reflect the fact that Judge Solomon was taking the Regents' case at face value and saying we can't accept new evaluate or new post-protest statements that were not part of the contemporaneous record. Next slide. There's also a case, BAE Systems Norfolk Ship Repair. This is a Judge Summers case, and he rejected an argument from the government. He ends up denying the protest, but he rejects a government argument that the cancellation of a solicitation could be based on any reasonable basis that's identified during the protest, rather than the specific basis, which was FAR 15206E, cited in the agency's decision. So the agency relied on one determinative basis for its decision, that FAR provision, and DOJ comes into court and says, well, maybe not. Maybe if we just identify a reasonable basis for this cancellation decision, we're okay. Justice Summers says, no, that's not going to fly under Regents, and rejects that argument. The last case I'll mention is Harmonia Holdings Group. This is an unpublished opinion, to be fair, and it's also on a motion to supplement the administrative record. And what happened here was there's a memo that's prepared by the agency after the cancellation decision. This is another solicitation cancellation case. After the cancellation decision and after the protest is filed. And so the DOJ introduces tries to supplement the administrative record with a statement that explains the cancellation decision. And here the court allowed the supplementation, even though the memorandum was drafted after the cancellation decision and after the protest was filed. I can't reconcile this case with Regents. I think it's problematic. It reflects essentially the GAO approach to this issue, and so I think it's an outlier. Okay, next slide. One issue that got addressed in 2022 is what happens if two evaluations exist. There's an initial evaluation, a protest, there's a subsequent evaluation during corrective action. How are those two evaluations to be handled, and what is the relationship between the two? In a case from July, LBB and Associates, the court notes DOJ's position, doesn't decide the issue, but notes that DOJ's position is that pursuant to Regents, when an agency takes corrective action, it is not limited to its prior reasoning and need not explain differences between first evaluation and reevaluation. I think that assumes that there's a new decision, right? Based on the Regents case law that we talked about. Anyway, that was DOJ's position in the July case. And then in October, in Connected Global Solutions, there's a case finding that where the agency had decided to conduct a new evaluation with new evaluation team, so new SSA, new technical evaluation team, totally new evaluation, the court said it was, quote, tantamount to examining the issue afresh, using the language from Regents, and held that the agency was not bound by the findings in its prior evaluation. My take on that is that's a pretty good interpretation of Regents. And I expect it'll be followed going forward, assuming the agency takes the necessary procedural steps to make a new decision. But I think it doesn't render that prior evaluation irrelevant, in my view. I think the prior evaluation can still be relevant if you're challenging the reasonableness of particular individual evaluations. If an agency has previously found X to be reasonable, and in a new evaluation it finds X to be unreasonable, why? And it doesn't mean by citing to that original evaluation and that original finding, it doesn't mean that a protester is necessarily saying it's controlling. I get that. I don't think that's right under Regents, but I still think it's relevant evidence to consider in determining the reasonableness of the second decision. So it's my take on that issue. I don't know. Panelists, you've probably come across this issue before. Thoughts on that one? No takers. All right. We'll go on. Lastly, couple things. Next slide. Sorry, Bill. Lastly, I want to return to the IAP Worldwide Services case, because in this case, Judge Solemson does a lengthy, thoughtful, thorough analysis of the court's remedies and equitable remedies, including talking about injunctions and remands of particular note. And so I'm focused on three questions here that he addresses. He addresses many more, and if you get into a thorny remedy situation, I would recommend the case for your reading. One of the questions that he addresses is whether there should be a remand or an injunction. So recall that he has concluded that the agency did not meet the DFARS provision. And so the question is, what's the appropriate remedy? Should I enjoin the agency and require them to take some action, conducting discussions, forming a competitive range, whatever? Or should I remand it to the agency and allow them, because they have some discretion, obviously, in this issue in the first instance, to make a new decision or to try to supplement their original decision? And what Judge Solemson ultimately does is he remands, and he cites to this case to this language, except in rare circumstances, and this isn't a quote, this is my formulation of it, except in rare circumstances, remand for additional investigation or explanation is the preferred path if, one, the record before the agency does not support the agency action, or two, the agency has not considered all relevant factors. Now, that's not new law either. That's been around for a long time. But it's maybe not been followed as frequently as it could have been in the past. And I think there is a new focus on, should we be remanding more decisions when these kinds of flaws are identified? This obviously doesn't apply to all kinds of flaws that would be identified in a protest. But when the record doesn't support the agency action, or the agency hasn't considered all the relevant factors, when that would be in a situation where remand may be appropriate. And that language, except in rare circumstances, that's from the Supreme Court. So he cites to that, and he decides remand in his case. In that case, a limited remand was appropriate. The second issue that it gets addressed, or another issue that gets addressed, is, does the remand require demonstration of irreparable harm? And here, I think the answer again is no. Judge Solemson says, look, I have to weigh the equities, of course, even in a remand situation, but it's not a situation where I'm applying the irreparable harm prong of the equitable relief test. So, and in fact, the court says if the court was considering injunctive relief, that the protesters' harm at that stage would be insufficient. But the court is only ordering a limited remand, and therefore that finding of irreparable harm is not required. I think that's important to keep in mind as we go forward. And then the last question, next slide, last question that's addressed that I think is interesting and that is often made. Next slide. Is a remand futile because the agency might reach the same decision? So the agency in this case says, well, I mean, you're going to send us back, you're going to make us have a new decision about discussions and a competitive range, and we think we were right the first time, and we're going to probably make the same decision around the second time around. So it's a futile act to send us back and have us do this again. And Judge Solemson says that such a position is not creditable under Regents, because in the Regents case, Justice Kavanaugh made the same kind of argument, the same kind of futility argument. Like, why are we sending this thing back to DHS? Why don't we just accept or consider the rationale that was provided in the second memorandum? And Justice Roberts says, no, that's not how the APA works. And we are going to stick to the rules of the APA for good reason. And so the issue of is it futile, I think is pretty thoroughly rejected. And the court ultimately orders the agency to either provide a fuller explanation of the agency's reasoning at the time of the agency action or render a new agency decision. So he just goes squarely down the path of what Regents has suggested. So those are the cases I wanted to talk about from 2022. I think they provide some good thought for going forward about how to deal with these issues. And they also, as we've identified, raise potentially some questions about how they might be interpreted in the future. Thanks.
Thanks, Rich. Good afternoon, everyone. I'm Jay Carey. I'm thrilled to be here, and I will start off here with another important other transaction authority decision coming out of the Court of Federal Claims in 2022 called Hydraulics, Inc., the United States. We seem to be averaging about one significant OTA decision a year. Recall we had SpaceX in 2019, MD Helicopters in 2020, Kinemetrics in 2021, and of course now we've got hydraulics in 2022. I'll start with some background and then turn to hydraulics. As we all know at this point, OTAs are defined as transactions other than contracts. They are not procurement contracts. We'll focus today mostly on the court, but just to touch on it, GAO hears protests, and of course, and those protests are defined as objections to the solicitation or award of a contract. And as a result, it's pretty well settled that GAO will not hear protests of OTAs, except that it will hear protests alleging that the use of an OTA was improper. Next slide, please. So turning to the court, if you want to bring your protest to court, things have been less settled. In terms of jurisdiction at the Court of Federal Claims, the court has exclusive jurisdiction over protests of any alleged violation of statute or regulation in connection with a procurement. And meanwhile, U.S. district courts have jurisdiction, general APA jurisdiction, except where the Court of Federal Claims has exclusive jurisdiction. So if a protest alleges a violation in connection with a procurement, the Court of Federal Claims has exclusive jurisdiction. If not, district court likely has jurisdiction. So the question is, when does a protest involving an OTA allege a violation in connection with a procurement? All right, with that, let's briefly revisit and refresh on SpaceX and MD Helicopters. Next slide, please. Okay, in SpaceX, of course, the protest was filed at the Court of Federal Claims. The Air Force had awarded OTAs for the development of launch vehicles and planned later to award procurement contracts for launch services. In SpaceX, the court found that the OTAs were related to, but were not in connection with the future procurement contracts for launch services. Why is that? Well, you see the court's considerations on this slide. The OTA and the future procurement contract were subject to separate and distinct solicitations. They used different acquisition strategies, and there would be no acquisition of goods or services in the OTAs. Now, the court also noted, in response to an argument that SpaceX made, that the future procurement contract competition would be full and open. There would be no down select. And so even a company that did not win an OTA would be eligible for the future competition. Based on those considerations, the court concluded that it did not have jurisdiction and it transferred the case to U.S. District Court in California. That district court took jurisdiction and ultimately ruled on the merits. I would say that the decision in SpaceX was quite fact specific. And from my perspective, at least, it was not entirely clear how the factors that the court articulated would play out in or be applied to other cases. And one question, I think, was whether the real driver of the SpaceX decision was the absence of a down select. The court did not say that, but I think it's worth noting that later decisions in MD Helicopters and in Kinemetrics seem to interpret SpaceX in that way. So with that, let's turn to MD Helicopters. Next slide, please. MD Helicopters was filed in U.S. District Court in Arizona. It involved OTAs for the development of a new Army helicopter to be followed by later phases. Now, in MD Helicopters, there were two clear differences from SpaceX. Number one, there would be a down select so that offerers who did not proceed through the OTA process would not be eligible down the road in later phases. But number two, it was not clear in MD Helicopters whether there would ever be a procurement, whether a contract would ever be used. It might be OTAs all the way down. The court in MD Helicopters considered that fact, that second fact, and concluded that it doesn't matter because the OTAs, according to the court in that case, took place within the process of determining a need for acquisition. And in making that point, the court was relying on the Federal Circuit's decision in Distributed Solutions. It didn't provide a whole lot of analysis, and we'll come back and discuss Distributed Solutions more in a minute. Ultimately, the court found that the Court of Federal Claims had exclusive jurisdiction, and it therefore dismissed the case. So at this point in 2020, we have one OTA protest filed at the Court of Federal Claims, which gets transferred to U.S. District Court, and we have another OTA protest filed in District Court, which gets dismissed. And in short, we have a whole lot of uncertainty about the right forum. So with that background, let's turn to hydraulics. Next slide, please. So here are the facts at issue in hydraulics. The Army sought upgraded aviation ground power units, or AGPUs, that it needed to service helicopters. And you see here the different phases that the Army anticipated. I'll highlight that in phase 3, the Army provided that the project, quote, may result in the award of a follow-on production contract. So hydraulics was like MD Helicopters in two ways. Number one, as in MD Helicopters, there would be a down select moving through the process. And number two, as in MD Helicopters, the ultimate use of a procurement contract was uncertain. Next slide, please. Now, I think it's important to note that, of course, both SpaceX and MD Helicopters, both of those decisions discussed Federal Circuit precedent, including Distributed Solutions. But I think it's fair to say that hydraulics has significantly more analysis of those decisions and how they apply in this particular situation. Now, we start, of course, with the fact, as I mentioned earlier, that the Court of Federal Claims jurisdiction depends on there being a violation in connection with a procurement or proposed procurement. And the Federal Circuit has said that in terms of the definition of the term procurement, we look to 41 USC section 111, which gives a fairly expansive definition, which you see on the page here. The term procurement includes all stages of the process of acquiring property and services, beginning with the process for determining a need for property or services. Now, remember, that's the language that the MD Helicopters court used. So the court in hydraulics looked at that definition, and it also looked at the Federal Circuit's prior decisions, particularly in Distributed Solutions. And I think it's worth noting that in Distributed Solutions, the facts in that case were that the agency had used a request for information, an RFI, to determine the need for a future procurement. Once the agency got the responses to the RFI, the agency decided not to proceed with a procurement, but instead to have an existing prime contractor issue subcontracts for the work required. The protester then challenged the agency's decision not to proceed with a procurement, and the Federal Circuit found that the Court of Federal Claims had jurisdiction. And the Federal Circuit reasoned that it does not matter whether an actual procurement occurred, because the Court of Federal Claims has jurisdiction over proposed procurements. So here, the Court of Federal Claims found that the Army was using OTAs like the RFI had been used in distributed solutions to decide whether to make a purchase, and if so, the parameters of the acquisition. And I'll just read one key quote from the decision, which I think is instructive. The court said, if the OTAs are part of the Army's process for determining a need for acquisition, then they are in connection with a proposed procurement, and this court has jurisdiction. So that's pretty broad language. I think it's important to note that. If the OTAs are used by an agency to determine a need, then they are in connection with a procurement, and the court has jurisdiction. Next slide, please. I have a couple of other key quotes from the decision here. The first quote echoes the quote I just read you. I think it's another important statement by the court. The court says, it is therefore immaterial whether the potential procurement ever occurs, so long as the government has initiated the process for determining a need for acquisition, and that acquisition might occur via procurement. So again, seems like a pretty broad statement, but I think it's also important to note that the court did not stop there. The court also considered whether there would be a down select along the way. And at the end of the court's opinion, it concluded, and this is the second quote that you see on the page, the OTAs in this case initiated the process for determining a need for acquisition, and they are in connection with that process because they may result in the exclusion of plaintiff for consideration of a follow-on production contract. So reading the opinion as a whole, it seems that the court was relying on both of two facts. Number one, that the OTAs were part of a process for determining a need. And number two, that there would be a down select. I think there are a couple of takeaways that, for me at least, from hydraulics. The first is that the case is another data point indicating that if you have both of those facts, then the Court of Federal Claims may take jurisdiction. That was the case in both MD helicopters and now hydraulics. On the other hand, in SpaceX, it seems like there were neither one of those facts. And there, the Court of Federal Claims did not take jurisdiction. And I think an open question is that it's not entirely clear at this point what happens if you have one fact but not the other. The second takeaway is that hydraulics is also another data point, again, along with MD helicopters, indicating that uncertainty regarding the possibility of a future procurement does not necessarily deprive the Court of Federal Claims of jurisdiction. But, and it's always important to remember this, the decisions of one Court of Federal Claims judge are not binding on the others. And so until we get a ruling from the Court of Federal Claims on this issue, we're going to remain with some uncertainty. So on the issue of OTAs, that's the significant development, and we'll have to stay tuned and wait for the next OTA decision. Before I move on, let me ask my panelists if they have anything they'd like to add or chime in with.
I'm glad to add a thought, Jay. Having been involved in the SpaceX matter and having been in this this tricky situation, I think a practitioner point is that in that circumstance, we did move for transfer if jurisdiction was not found under 28 USC 1631. And certainly, I think that's an appropriate position to take if you're going to the Court of Federal Claims. I disagree with the court's decision in SpaceX. I think hydraulics is much more fulsome decision on these points, but nonetheless, I mean, it is out there as a decision, and certainly the court resolved it to its best of its ability and ultimately transferred SpaceX to the Central District of California, where, as you mentioned, it was heard. But from a practitioner point of view, if you're caught in this situation, there's no reason to leave yourself hanging out there. Put the motion into, file at the court and put the motion into.
Good point. Rich, I saw you went off mute. Anything that you wanted to add?
Yeah, I was just going to say, I think from my perspective, and it echoes what Craig just said, this is helpful in clarifying that going to the court in the first instance is probably the best idea, but including a motion for transfer if necessary is kind of the protective plan. But I think this is good language and is going to cover a lot of different situations. So I was encouraged by this decision for the contractor community.
Yeah, it certainly does add some clarity. Okay, so moving on to developments in blue and gold, if we can go to the next slide. Blue and gold fleet has been around for a while now. It was decided in 2007. Seems like it's been longer than that. And as some or many of you may recall, a couple of years ago, we had a decision called Insurso out of the Federal Circuit, which I think led to a lot of discussion about whether the blue and gold doctrine was expanding. And, since Insurso, we've had a couple of decisions that might point in the opposite direction. So let's dive in and take a look. Next slide, please. Just as some background, as we all, I'm sure, know, the basic doctrine or holding of blue and gold is that a protester must object to a patent error in a solicitation prior to the close of the bidding process. A few years after blue and gold, in 2015, the Federal Circuit issued its decision in Banham. And there, the court indicated that, quote, a formal agency level protest before the award would likely preserve protest claims. But the Federal Circuit also found that objections falling short of a formal protest would not. So I want you to hold that idea in your head. We're going to come back to that. Then, of course, last year we have Harmonia, which we addressed in this forum last year. And very briefly, in Harmonia, the protester filed an agency level protest, which was denied. About 4 or 5 months later, Harmonia then filed a protest after an award had been made. And the question was, had Harmonia done enough to preserve its protest claim? And the Federal Circuit said that, and you have the key language on the page here, a bidder's timely formal challenge. So note, Banham said formal agency level protest. Now we have timely formal challenge of the solicitation before the agency removes a case from the ambit of blue and gold. Okay, so with that background, let's move on to a case decided earlier this year, Secre. And if we could go back to the next slide, thank you. Here are the facts in Secre. The agency was Defense Logistics Agency, DLA, which issued a full and open competition for ATAPs. An ATAP is apparently a harness worn by paratroopers to carry all their weapons and gear as they jump out of the airplane. And again, DLA decided to hold a full and open competition for the provision of those items. Source America informed DLA via an email that Secre was the mandatory source under the AbilityOne program and the Javits-Wagner-O'Day Act. So in other words, the law required DLA to source the ATAPs from Secre as a mandatory source, and DLA was not supposed to engage in a full and open competition. DLA responded that it would proceed with its full and open competition. And at that point, SECRE took no further action. The deadline for proposal submission came and went on October 7th of 2020. And SECRE did not bid. Then on January 21 of 2021, SECRE filed a protest at the Court of Federal Claims. So this is now months after the deadline for proposal submission has passed. And the Court of Federal Claims dismissed the protest based on standing because it found that SECRE did not bid or diligently pursue a protest prior to the close of the bidding process. And it also dismissed based on blue and gold because, again, it found that SECRE had not filed a protest before the deadline for proposal submission. SECRE appeals, and that brings us to the decision by the Federal Circuit. If we can go to the next slide, please. Okay. So I'll touch briefly on standing, though I want to focus, of course, on blue and gold. The Federal Circuit found that SECRE had standing because it was a mandatory source. And so therefore the circuit concluded that SECRE was not subject to the usual requirement to either bid or diligently pursue a protest before the end of the bidding process. Turning to the blue and gold issue, the Federal Circuit also found that SECRE's protest was not barred by blue and gold, even though it had not filed any protest before the deadline for proposal submission. And we have some of the key language here on the slide. The court found that SECRE satisfied its obligation under Harmonia to submit a timely formal challenge of the solicitation. Now remember, all SECRE did was have Source America on its behalf send DLA an email notifying DLA that SECRE was the mandatory source. So SECRE did not file a formal protest in any sense. The court went on to find, and this is the second quote on the page, that DLA's awareness during the bidding process that SECRE is the mandatory source for ATAP removes this case from the application of the blue and gold standard of waiver. So notice to the agency, in this case at least, the court suggested was enough. Okay, so let's stop for a minute and compare SECRE with BANNM. In BANNM, I think it's worth noting that the protester submitted a letter laying out its concerns, and it even called its concerns an agency protest. And if you look at the opinion of BANNM, it appears that the protester even it put agency protest in all caps in its letter. But in BANNM, the Federal Circuit ruled that that was not enough because BANNM had not followed the formal procedures for an agency level protest that were laid out in the RFP. And in BANNM, the Federal Circuit also said that an agency's awareness of the problem was not enough to escape blue and gold. And here's the key quote from BANNM. We conclude that mere notice of dissatisfaction or objection is insufficient to preserve BANNM's defective solicitation challenge. So in BANNM, a formal protest was required to preserve the protest claims. Now, under Harmonia, a formal challenge is enough. And under SECRE, at least, an email satisfies the requirement for, or satisfied in that case, the requirement for a formal challenge. So what's going on here? Well, it could be that the ruling in SECRE is limited to the AbilityOne program and the fact that SECRE was a mandatory source. It's not clear that that's the case, though, and I think it's worth circling back to the Insurso decision from a couple of years ago. Now, Insurso, as we all recall, I'm sure, had a very odd set of facts. And I'm just going to highlight them very, very quickly. There was a two-track procurement. And the agency made awards in the first track and gave debriefings in the first track before it made award in the second track. And the protester argued that the information provided in the debriefings in the first track conferred an unfair advantage to those offerers who were competing in both tracks, conferred an unfair advantage in the second track. The Federal Circuit deemed that to be a patent defect in the solicitation and applied blue and gold to bar the protest. And as I mentioned, many of us wondered whether that signaled an expansion of blue and gold. But since then, we've had Harmonia and now SECRI, which both arguably constrain the doctrine rather than expand it. So what gives? Well, let's take a look and revisit the dissent in Insurso. If we could go to the next slide, please. So the dissent in Insurso was written by Judge Reyna, and it argued, Judge Reyna argued that the Federal Circuit should do away with blue and gold, and he pointed to the Supreme Court's 2017 decision in SCA Hygiene, where the Supreme Court held that courts are not at liberty to jettison Congress's judgment on the timeliness of suit. In other words, where Congress has established a statute of limitations, the court should not impose a shorter judicially created time bar. Here, of course, 28 U.S.C. 1491 establishes a 6-year statute of limitations for actions under the Court of Federal Claims' jurisdiction. And Judge Reyna in Insurso reasoned that, and this is the second quote on the page, given this clear congressional directive, we cannot curtail the 6-year limitations period for challenges to patently defective solicitations. So here's an interesting fact. The decisions in Harmonia and SECRI were both authored by, you guessed it, Judge Reyna. Now, neither of those decisions revisits the propriety of blue and gold in the light of SCA Hygiene, but instead, both decisions make a point of finding that the facts of those cases were outside the ambit of blue and gold, and in the process, arguably narrow the application of the blue and gold doctrine. So we'll all have to watch and see where this goes as we get new blue and gold decisions out of the Court of Federal Claims and the Federal Circuit. But I also think it's worth noting, as I said last year when we talked about Harmonia, that it's important that protesters not get complacent. For one thing, it's not yet clear how broadly the reasoning in SECRI will apply. For another, blue and gold is not the only pitfall that you need to worry about as a protester. As Harmonia reminded us, the Court of Federal Claims has broad discretion in fashioning a remedy. So the bottom line, as always, is that waiting to pursue a protest almost always comes with some amount of risk, and you should proceed with caution. So that's my update on blue and gold. Again, before I pass the baton here to Adam, do any of the panelists want to add a further comment?
I think you nailed it, Jay. I mean, it's SCA Hygiene and Judge Reyna have marked a point in the necessary narrowing of blue and gold. And, you know, there's only so much that can be done by the by practitioners at this point in time, except to be careful, as you noted.
Thanks, Greg. Adam, over to you.
Thanks, Jay. You know, I think just on that point too, I think it almost seems like with the SECRI decision, it's somewhat of a situation of, does the government have enough information to make a corrective action decision itself based on something that the potential protester did, which is almost more like the standard we see in a cost decision at GAO. But Anyways, obviously there's still to be development in that and potentially some congressional development at some point down the road, depending on how much it gets eroded. So anyways, my name's Adam Lasky. I'm partner and co-chair of the government contracts group at SIFART. And I am going to talk mainly today about the government control exception and whether it applies to electronic proposal submissions, as made particularly relevant this year by the eSimplicity case at the Court of Federal Claims. And why did I choose this to talk about? I think that when you look at this issue, this is probably the largest split between the GAO and the Court of Federal Claims of any issue out there today. And I say that there are plenty of things that where the court doesn't agree with the GAO, and I know that Craig is going to talk about one of those later. But this is a matter where the judges of the court have not agreed on this issue either. And of the cases where the court has diverged from the GAO's position, which is the majority of those cases, the judges have issued substantially different reasons for those departures as to why they reached those positions. And this is a situation where the cause of this is effectively either you could say poor regulation drafting, but more, I would say the regulations have not kept up with technology. And this was an area where that was very likely to happen. And unlike other situations where we talk about electronic submissions, for example, claims and whether you have to sign them with pen or typewritten, that kind of situation was resolved in 2020 by the ASBCA. It wasn't actually in the regulations. It was just changing of common law, effectively adapting to changes in technology. But here we're dealing with a situation where there's actually regulatory language that the court and the GAO has to work with that cannot be changed absent some action. So next slide, please. So just real quick, like I said, this is regulatory. So, these cases really depend on interpreting regulations. There's a lot of lessons from this just in general, how regulations are interpreted to totally other protest grounds. But the late is late rule and the exceptions. So offers are responsible for submitting a proposal to reach the government office designating the solicitation by the time specified in the solicitation. Any proposal received at the government office after the deadline is considered late. A late proposal can be considered if it was received before award, the contracting officer determines that accepting a late offer would not unduly deflate the acquisition, and one of three other exceptions applies. Next slide. Now, before I go into these exceptions, there are actually two more exceptions that I'm not going to talk about them today. One deals with basically extreme weather issues. Another is a GAO created exception for government interference effectively in a hand delivered proposal, but they don't fall under the same rubric as these three exceptions. So the first is the electronic commerce exception. If the proposal was transmitted through an electronic commerce method authorized by the solicitation, and it was received at the initial point of entry to the government infrastructure not later than 1 working day prior to the deadline, that exception can apply. The second is the government control exception. If there is acceptable evidence to establish that the offer was received at a government installation designated for receipt of offers and was under the government's control prior to the time set for receipt of offers. The third exception is if it's the only proposal received. Now I will note that exception actually reads, so this exception is stated in FAR 15208 as well as the FAR provisions for commercial items and for FAR Part 15 proposals, 215-1 and 212-1. This language of the third exception actually reads slightly different between the FAR Part 15 language and the FAR Part 12 language. We'll go into that a little bit later. Next slide, please. So I'm going to provide a little backdrop as we get to the eSimplicity case, because there's about 20 years of case law on this and how this has evolved, the interpretation. So the first case is called C-Box from 2002, and GAO looked at this. The question is, does the government control exception apply to electronically submitted proposals, or is the only exception applicable to electronically submitted proposals the e-commerce exception? That's the fundamental question these decisions have addressed. The C-Box case is the first case that I'm aware of addressing this, and the GAO said that the government control exception does not apply to electronically submitted proposals. And the reasoning GAO provided was that the first exception, the e-commerce exception, by express terms, applies to electronically submitted proposals. And if it were to be read, the government control exception were to be also read to apply to electronically submitted proposals, it would effectively make the e-commerce exception a nullity, because the e-commerce exception requires submission the day before, whereas the government control exception only requires submission by the receipt by the proposal deadline. And the GAO said, in spirit of the rule of giving all words meaning and general versus specific, we believe that the e-commerce exception is the only exception that applies to electronically submitted proposals. So then in 2004, in the next case, ConScoop, the Court of Federal Claims got this issue. Now, this issue wasn't actually central to the case. In this case, there was some question of what was the time zone that the proposal deadline was in, and that was the central issue in the case. That being said, the court actually said that they quoted from the C-Box decision, and it said that the court agreed with the C-Box reasoning that the government control exception did not apply to electronically submitted proposals. But again, it really was true dicta in that case. That case was actually affirmed by the Federal Circuit, but again, this issue with the government control exception really did not come into play at all. The next case, and the first case where the court really addressed this, is a case called Watterson from 2011. And in this case, essentially what happened was there was four servers that an email needed to go through on the government side before it would actually reach the inbox of the contracting officer. And the proposal hit the first government server 31 minutes before the deadline, but because of issues that were going on the government side, it didn't actually reach the contracting officer's email box until 4 minutes after the deadline. And the court looked at the issue of the government control exception, but also looked at, was it even late? Was the proposal even late at all? And the court ruled it was not late, and that the government control exception applied. In terms of the late issue, what's kind of important in the court's decision was that the court determined that the government office designated in the solicitation, which is the language for whether it's late or not, is it received in the government office, whereas the government control exception concerns government installation. The court said that government office was the contracting officer's email address, which the court interpreted to mean the government's email servers, not the contracting officer's inbox. And the court said that this was the first decision that had addressed that issue. But in addition, the court also construed the government control exception to apply to email proposals. And the reasoning, the plaintiff actually raised a regulatory history argument, which actually is pretty interesting. They pointed out that originally there had been exceptions in the regulation that were designed for all the different types of delivery methods, which included, there was a specific exception for registered mail, for hand delivery and fax, for express mail, and then there was the electronic commerce exception, and then there was still the government control exception. And so the plaintiff argued that the fact that looking at the regulation as it existed before, indicated that the government control exception was not limited to just things that were not electronic submissions. The court adopted a regulatory history argument, but not that regulatory history argument. The court came up with a different regulatory history argument to support its interpretation. And the court basically determined that that the e-commerce exception was intended for something called batch processed electronic commerce, which predates my knowledge of email a little bit, but essentially involves submissions that came into the government and then would not be sent out to the inbox until the next day, which is according in court at that point in 2011 didn't really exist anymore. And the court basically said that took that to mean that the electronic commerce exception was really intended only to apply to batch delivered electronic commerce, and therefore essentially read into the government control exception that it applied to all proposals delivered through non-batched delivered electronic commerce. So the next case after that is called Insight Systems. Now this case is with the case we're going to talk about, eSimplicity. eSimplicity takes issue with both Watterson and Insight Systems, but in reality is pretty close to the reasoning in Insight Systems from 2013. So in this case, the proposal made it to the government, to the first electronic server on the government side prior to the deadline, but then was bounced back before it made it to the next server. The server it actually made it to was actually operated by a third-party contractor on behalf of the government. The courts held that the government control exception applied to electronic submissions and really focused mainly on really did not focus at all on the reasoning that the Watterson case had provided, decision had, and instead really focused on the plain meaning of the regulation, and that there was nothing that said in the government control exception that it was not applicable to electronic submissions, and there was nothing in the electronic submission exception that said it was the only exception applicable to electronic submissions. Importantly, this court, and what Watterson had not done, was analyze whether a government installation, whether a computer server really was a government installation that received the offer versus the inbox. And the court looked at that there was no definition of the word installation in the FAR, and that the dictionary definitions were very broad of installation, including one that the court cited was a system of machinery or other apparatus set up for use. And taking the broad definitions in the dictionaries, the court basically said that the servers are effectively the same as a mailroom, and therefore would be considered an installation that could receive electronic submissions. And the court rejected the nullity argument that GEO had been relying on. Next case is called Federal Acquisition Services Team. And that one doesn't add a lot more to this other than just adopts Watterson and Insight. Following that, so now we're at 2017, and the next case is called Peers Health. So now we've got a line of court cases that have disagreed with GEO, and there have been a number of cases, GEO cases spread out through here that don't really add anything. Peers Health pretty much just restated the argument that GEO had made in CBOX, and it still said that the government control exception did not apply to electronic submissions because otherwise it would render the language in the electronic submission provision a nullity. In the next case, People, Technology, and Processes, again, just relied on CBOX, the next case, Bill. But what is interesting in that case is that the GEO actually does include a footnote in the decision recognizing that there is a split between the GEO and the court on this issue, but does not actually address that split at all. Doesn't explain why the GEO's position is right or how it's different. Just recognizes there is a difference. And then the next case, Versa Integrated Solutions, which is from this past year, just pointing out that, in this case, actually, the protester asked GEO to adopt the Court of Federal Claims line of cases and overturn its prior decisions, which GEO did not do. And again, just really restated the logic in CBOX that it would render the e-commerce exception a nullity. So that gets us to eSimplicity. So in eSimplicity, next slide, please. So in eSimplicity, the proposal were due on April 25th. The RFP specified a 30-page limit on proposals, but didn't provide a maximum file size. It actually also mentioned that offers are responsible for ensuring that the submissions are virus-free. but again, didn't say how big the submission could be to be accepted in terms of megabytes. So eSimplicity emailed its proposal to the specified email address prior to the deadline. It was over 20 megabytes in size. The eSimplicity didn't receive any confirmation that its proposal had been rejected by the server or had been accepted. The next day, eSimplicity contacted the Navy and learned that its proposal had never been delivered to the Navy email address. Upon investigation, the Navy discovered that the DISA managed server, the initial point of entry, had had accepted the proposal email, queued it for delivery to the Navy's destination server, but had been bounced back because the file size was too big. Presumably, there was a 20 megabyte limit of some sort that prevented that server from taking the email forward. Next slide. So the protester argued that rejection of its proposal was arbitrary and capricious for two different reasons: unstated evaluation criteria, the email size limit, and the government control exception. It should have been considered under that. Now, I'm not going to go much into this unstated evaluation criteria, although that is actually the basis for the decision more that that was the ultimate grounds for granting an injunction, was the unstated evaluation criteria. Basically, the court ruled that in effect, the Navy had rejected the proposal because its size exceeded the file size limits, but the Navy had not said there was a file size limit in the RFP that would cause rejection, that would cause the proposal not to be accepted. And while the decision doesn't go into the detail that much as to what the submission instruction was, like I mentioned, there was even a submission instruction saying you had to ensure your proposal was virus free, but there was still nothing, and a page limit, but there was nothing that said what the size part was. Now I'll note that while GAO hasn't seemingly seen maybe an argument, at least I can find, that's conveyed this exactly this way, it seems that GAO would probably reject this argument based on some of its prior decisions. It seems to, I have noted a couple here, Ace Electronics and Eris Management, which suggests that because it's the offeror's responsibility to ensure that these proposals are actually received, that there seems to be a heightened standard, maybe of inquiry here, and that if the RFP, it seems like GAO's position is if the RFP doesn't say what the megabyte size limit is, it's on you to find that out, and it's effectively a patent ambiguity by not inquiring. But we're not going to, the real focus is the government control exception. So next slide. So like I said, the court, Judge Schwartz did not really agree with the Watterson reasoning at all, and thought that the Insight Systems case did not adequately address the issue to the level that the court thought it was necessary here, and found that there wasn't, in the court's view here, in eSimplicity, there wasn't clear guiding case law to be helpful at the GAO or the court level. But ultimately, even the court eSimplicity agreed that the government control exception did apply to electronically submitted proposals, but did not determine whether or not it would have essentially applied under these facts. Next slide. So the court basically determined there were, the primary issue it looked at was, would the electronic commerce exception be rendered a nullity if the government control exception is interpreted to apply to electronics proposal submissions? And what the court looked at, it sort of framed it as two questions. The first was, would there be potentially a set of facts where the electronic commerce exception would apply, but the government control exception would not apply, even if the government control exception was determined to encompass electronic submissions? And the court said, yes, there would be. And the court pointed out that there were textual differences between the language in the government control exception, which required both receipt at a government installation, as well as the proposal being under the government's control, and the electronic commerce exception, which did not include anything about control and also used different words. It didn't use government installation designated for receipt of offers, but rather the initial point of entry. And basically the court said that you have to give these words meaning, you have to take them seriously. And there's clearly going to be situations contemplated where the proposal could be considered to have made it to the initial point of entry, but not have been received at the government installation designated for receipt, or not under the government's control. The other question that the court looked at would be, okay, the government is arguing that the interpretation advocated by the protester would render the electronic commerce submission superfluous. And so does that rule apply anyways? And the court looked and said, well, would the government's own interpretation render the regulation superfluous? And the court said, yes, the court's own interpretation would render the under control language superfluous in the government control exception. And therefore the court said the rule that the government is asking, the surplusage rule, could not be applied here anyways, because both interpretations would end up with some degree of surplusage under the government's own argument. Next slide. So we'll skip over this, but this is sort of just an explanation of what I just said, just the difference between the two explanations. The GOs presented why it would be a nullity and why the court in e-simplicity says it's not a nullity. Next slide. The other thing that I think is pretty important here is the court said that a recent decision, Rimini Street, from the US Supreme Court in 2019, essentially is saying that the surplusage rule is not a fundamental rule of regulatory interpretation, but rather is merely a clue for better regulatory interpretation. And there may be certain circumstances where the better overall reading does contain some redundancy. So to suggest that this was not, even if there was some degree of nullity, it wasn't actually dispositive. And the other thing that the court rejected was the government specific versus general argument. What the government argued was that the language, if a proposal is transmitted through electronic commerce in the e-commerce exception, implied that that was the only possible exception that could apply to electronic submissions. What the court looked at was the fact that the third exception, the only proposal received exception, also says if the solicitation is a request for proposals, then the only proposal received. And the court said, well, under the government's argument, then even the e-commerce exception wouldn't apply if the proposal, if it is a RFP, and therefore if it's an RFP, the only exception would be the only proposal received exception, which the court said that didn't make sense. Now, I would note though that that's not how the regulation, or in this case, the provision reads under FAR Part 15. That's only in the FAR Part 12 provision. There is no if this solicitation is a request for proposal language in the FAR Part 15 provision, but this decision was under the FAR Part 12 provision. Next slide. So I think, this case actually, I think, opens more questions in some ways than the prior decisions at the court did as to where this stands. In rejecting the surplusage nullity argument, the e-simplicity and insight decisions depend, at least in part, on the idea that there is a set of facts where an offer submitted via electronic commerce could be received at a government installation designated for receipt, but not be under the government's control. And I think there's a question of, is that correct? That the e-simplicity decision doesn't go on to apply that fact pattern. So they suggest that that is possible, but don't apply it in that case. The government control rule is actually relatively well agreed to by the GAO and the court. Basically, a proposal is under the government's control when the offer relinquishes control over the proposal such that it can no longer modify it. And the GAO's not exactly using the same language, but very similar. And there's a number of cases on this, both from hand delivery type situations where somebody basically entered the facility, but did not hand off the proposal yet. And so therefore it was ruled that the proposal was still under control, or upload cases where the government, essentially the proposal had been uploaded, but not been released by the offer. And so it was still under control. And I think that it's probably pretty true that in the context of an uploaded proposal, there's certainly going to, by those cases, it would be situations where it could be received at the government installation, but not under the government's control. I'm not really sure there is such a scenario under the email proposal scenario. I don't think that necessarily changes in the e-simplicity decision. The court said if there's any set of facts where an electronically submitted proposal could be where it wouldn't render, we're looking these two exceptions together, wouldn't render one a nullity, that would be enough. But I don't know if there would be a scenario with an email proposal. I don't know what the other panelists think about that, if you guys have any thoughts.
Yeah, my thought is we need a regulatory fix on this issue. I mean, to circle back to what you said originally, gosh, just think of the time and money that's, spent litigating these issues and within the government trying to figure out what the answer is. And the policy reason for the rule is pretty narrow. And I think gets to the question about, is there time to change the proposal? Is there some way to change the proposal? So that's a great explanation of the case law. And I've had to look at this issue as well, but it just screams out for a regulatory fix from my point of view.
Yeah, I think another issue, and going to the next slide here, although I question whether a regulatory fix will ultimately be, this is a situation where technology is going to constantly change. So, will a regulatory fix work? But certainly there could be something. I think another issue where I think arguably e-simplicity is actually narrower than the prior decisions because it sort of opens the door to I think it questions whether the first government server really is in all situations the installation for receipt of offers, whereas the Watterson and the Insight Systems cases sort of just said it was. And in fact, in the Watterson and the FAST case, the government server at issue that did actually receive the proposal wasn't actually even the same agency's server, but those cases said that didn't matter. I think that, the question is, could the government maybe include more specific language in the RFP if they didn't want to have this issue, to say that the point of receipt for defining what the installation is in the RFP? And I think that might be the best thing for the government to do to avoid this scenario. The other question I think this leaves is there any still remaining merit to the Watterson decision, which said that the proposal wasn't even late? Now, going to Rich's point, hopefully there will be some sort of regulatory review of this. Now, the e-simplicity decision has been appealed, but at the same time, the lower case has been dismissed because essentially the agency took corrective action based on the other part of the decision. I think they canceled the procurement, but there's still an appeal. So there could be a scenario where this is resolved by the federal circuit, but who knows? I was going to talk about another case, but I think we're really cutting into Craig's time. So I think I'm going to skip over that one, but I do commend you all to look at the Orland's PC case, which is a very interesting discussion of customary commercial practice.
Hey, everybody. Thank you for having me here today. I appreciate the opportunity to speak with you all. I'm going to try and cover 4 what I think are pretty critical interesting topics to government contractors that occurred in 2022, and I'm going to try and do it in 10 minutes. So I'm not going to be able to discuss the facts of the case. I'm just going to try and give this to you in a highlight fashion. Issue number one that I want to cover today: does government contracts have a new golden rule? I think it's fair to say that among the most important issues that the bid protest community has faced in recent years is key personnel in government contracting. We've had over the past few decades, we've had a real explosion in service contracting, and consequently, it's unsurprising that agencies have increasingly relied on key personnel evaluation criteria. And into that mix, we've had a series of rules, primarily driven by the Government Accountability Office, but also out of the Court of Federal Claims over the years, that have created some difficulty both for the contracting community and for government procurement teams related to key personnel. I want to touch very quickly on GAO's rules and where we stand in that realm. And then I'm going to touch on the golden decision out of the Court of Federal Claims, so everybody understands where key personnel stands at the end of 2022. First of all, GAO looks at key personnel issues in procurements and specifically misrepresentation of key personnel in procurements through two lenses. First of all, if you're talking about did an awardee misrepresent its key personnel based on information the awardee had before it put its proposal in, then it's looked at through the lens of a bait and switch. And you can see this is a three-part test that's set forth on the screen right there for a bait and switch. The awardee either knowingly or negligently represented that would rely on specific personnel that it did not have a reasonable basis to expect to furnish during the contract performance. 2, that the misrepresentation was relied on by the agency. And 3, that the agency's reliance on the misrepresentation had a material effect on the evaluation results. The decision there, ASRC, is a late 2022 decision, and it actually was sustained by GAO, and GAO actually required the exclusion, or recommended the exclusion of the awardee from that procurement ALRUP based on misrepresentation that occurred before, based on facts that ALRUP knew before proposal submission. Next slide, please. GAO also has a separate line of cases that deal with, and this is the more difficult and troublesome for, I think, contractors and government alike. There's a separate line of cases that deals with the circumstance where a awardee learns that its key personnel are no longer available after submission of proposals or final proposal revisions, if they are there. And what is the obligation of the company in that circumstance to do when it learns that a key personnel that's going to be evaluated by the agency is going to leave or has left the company after proposal submission? And what GAO has said here is that if the company is aware, it is to notify the agency, and the agency then in that circumstance must either exclude that offer or reopen the procurement for discussions. This is obviously a difficult rule for both contractors and government procurement teams. It is especially difficult because of the increased movement of personnel in the general economy at this point. So this is a circumstance that arises with some regularity. GAO has said you must notify the agency, and the agency then must either exclude the offer or reopen for further discussions. Into the picture now, next slide please, comes the golden IT decision. On February 4th, 2022, the Court of Federal Claims by Judge Solemson issued its decision in golden. It's a fascinating decision. It talks about misrepresentation generally and the genesis of misrepresentation. I don't have time to go into that today. It even posits the question of whether misrepresentation ought to be a viable protest argument at all. But that's not what I want to talk about here today. What's important here today is golden IT specifically breaks with GAO on what must happen with respect to key personnel if a contractor learns that its personnel are leaving or won't be available for performance after proposals have gone in. So this is the second of GAO's rules. And what the Court of Federal Claims said in Golden IT is that it could not find any basis for a requirement that a contractor notify the agency in such circumstance, and it was not going to apply that rule. And it's very important because it sets up a circumstance where we have a split between the Court of Federal Claims and GAO, or at least Judge Solemson and a few other judges who he relies on at the Court of Federal Claims and GAO. Next slide, please. So this next slide tells us where the state of the law is right now on key personnel. And importantly, if a contractor knows before it puts its proposals in that key personnel are not going to be available that it is proposed, so it misrepresents the key personnel in its proposal, it knowingly does it or negligently does it, both the GAO and COFC agree that that's a viable protest argument, and it would likely receive similar treatment at both fora. So where GAO and the Court of Federal Claims disagree at this point, at least certain judges at the Court of Federal Claims disagree, is that absent an express solicitation notice requirement, the Court of Federal Claims, Golden IT, and as I mentioned, Judge Solemson cites two other court decisions, could well reach an opposite conclusion based on a disagreement regarding the existence of an obligation. Again, the court does not believe that there is an obligation to give notice to agencies after proposals get submitted based on the departure of a key personnel. Next slide, please. Very quickly, I'm going to touch on just a topic that I think is of significant interest to the contractor community at this point, cybersecurity, and ask the question, will protests regarding cybersecurity certifications become the new issue du jour for protest counsel? Next slide, please. If you have time, I commend to you reading American Fuel Cell and Coated Fabrics Co. This is a denied protest, but very significantly, it's denied by GAO based on lack of prejudice. GAO actually went into and evaluated whether the agency had properly assessed compliance of the contractor with DFARS 252, 204, 7019, and 7020 to increasingly regularly used DFARS provisions in government contracts. So my prediction is that we're going to increasingly see this as an issue in bid protests. Next slide, please. Quick hit on timeliness traps for the unwary. One of the more interesting topics that actually came out of GAO twice in 2020 was the effect of communications with an agency pre-award regarding solicitation complaints and concerns. Next slide, please. What GAO has said in vSolvit and Science and Technology Corp, citing back to Coulson Aviation, is that de facto agency protests can trigger the obligation to file at GAO under a 10-day agency protest denial rule. So in vSolvit and Science and Technology Corporation, we have two instances in which contractors went to contracting agencies during the procurement process, raised concerns about a procurement, did not, at least superficially, did not realize they were filing agency protests. The agency rejected their request to revise solicitations. In GAO, they then went to GAO at a later time following GAO's timeliness, typical ground rules timeliness rule. Remember, under GAO's rules, you can file a pre-award protest anytime up to the time for submission of proposals. You can file a ground rules protest. In both vSolvit and Science and Technology, GAO said, no, that rule doesn't apply because you filed the de facto agency protest when you emailed the agency, or when, in one case, when you wrote a letter of concern, the other case when you sent an email to the agency, which the agency rejected, setting in place GAO's rule under 21283, saying that you have 10 days to go after an agency protest denial. This is a really tricky circumstance for contractors. Because FAR 3103 encourages contractors to raise concerns even before filing an agency protest with an agency to see if they can reach resolution with the agency. And indeed, what happens now under GAO's rules, if you raise certain concerns with an agency and it's effectively meets the definition of an agency pre-award protest, even if you don't call it one, GAO may treat it as one, requiring you to come to GAO within 10 days of the agency's action on that email. Just a trap for the unwary to be careful. If you do get caught in this trap, remember Harmonia Holdings that Jay talked about, and potentially you can go to the Court of Federal Claims. I see we're at 150, folks. The remaining of the slides will be available talking about protests by the numbers and what's going on with GAO's numbers and bid protests. Thank you for your time today.
Craig, thank you. And thanks to the entire panel for doing a stellar job of covering an enormous amount of material in a relatively short period of time relative to the amount of time we made available to you. Thanks to Rich and Jay, Adam, and Craig. We appreciate it. As a reminder to everybody, all of the slides are available for download on this panel from the PubK website. And as each panel begins, the slides for that panel will be available following the conclusion of the entire program. All of the slides and the transcripts from each session will be available. We're going to shoot for Friday the 13th. I don't know if we'll make that. It might be a week or so into the following week before we're able to do so. So a big thank you to our panel members for their outstanding presentation. Let me again thank our event sponsors for their support. Their names are listed on these next two slides. And thanks, and we look forward to seeing you at future PubK 2023 annual review sessions.